detailed response to much of what you had to say, but before I begin, I want to say thank you for your detailed comments. And those of you in the room who are graduate students, David Tzvi and Yael, this is, if you are exceedingly fortunate when you defend your dissertation, you will have the level of close attention paid to your work that Dean Harris has just paid to mine, and I'm very touched that you gave me that kind of attention. Thank you very much.
It fits back into my work, so in a way.
Nonetheless, I'm very appreciative.
Back to my research as well.
And I think that you bring up some of the questions. It's interesting to see how someone else reads my own book, and some of the claims I thought I made in the book versus what you see, and some of what is behind this project, and versus what we focused on. I think for starters, I think there is a theory behind what I spoke about today, and I'm really glad that you pointed it out. This idea that law changes with economic changes, with social changes, and so on. And this is something that I think Mark Cohen takes as a jumping off point, or maybe not as a jumping off point, but it's the major point which he wishes to demonstrate in his current book on the Rambam. That is to say, I take it for granted that social, economic, cultural changes and linguistic changes are accommodated by jurists. That is to say, when Maimonides sees earlier Talmudic materials, he doesn't understand them the way that they were understood 600-700 years before. He might attempt to, but he has no explicit, to my knowledge, theory of how he reads Talmudic principles in light of Talmudic history, the way that someone like Clarence Thomas, let's say, might try to read the American Constitution into its original intent. On the contrary, he reads his contemporary context into it, which means there is a natural progression. And to that end, I think that the point that Mark Cohen makes, it would be a starting off point for how I would understand Maimonides to read his earlier sources. I think the important contribution that Mark makes in his forthcoming book is identifying specifically where Maimonides tweaks his Talmudic sources in light of contemporary practice. But the fact that he does so is, at least to my mind, sort of the jumping off point. So that connection between law and society, I think, is very important. So there is an underlying theory in my work, in this project, that economic changes find form in changes in law. I think that your statement that different genres of law will change at different rates is very important, and that's something that I really could take into account. One problem that I have is this is what we have, right? I mean, that is to say, we have many Geot and Tshuvot, we have Halachot Rabati, we have the Mishneh Torah, but before the Geniza, right, what evidence do we have of that commercial practice to which we can turn other than these sources, right? I do think, however, that your introduction of archaeology, the number of shipwrecks and so on, the persistence of cities in one or another place on the Mediterranean littoral, that's critically important, and it's something that I'm trying to incorporate now, to think about what other migrations can we identify. Was there a broad westward migration among the Islamic populace, and was the Jewish migration simply a piece of that? And along that migration, there is, of course, a legal migration too. So how can we identify that? This is all very valuable, and so I hope we can continue the conversation.
I will short remark about the possible reactions of changes in economic life by the legal system. Take the suffrage as I want. Commerce need commercial instruments. It makes the life of the commercial much easier, much flexible, and so on. Now in Jewish law, you don't, in Talmudic law, you don't find something like a bill of exchange, commercial instrument, not the suftage. But you can now, to try to develop such a legal institution. And you can do it in two different ways, even in two opposite ways. You can do it by to try to take some legal institution from the Talmud and develop them. And then you have two main obstacles. One, the need of a new deed in order to sell a deed. And when you sell a deed, which is really the case of using commercial instrument, you need to write an additional deed. It is usually complicated, it costs money and so on. This is one problem. And the more important obstacle is the rule, המוכר שטר לחברו וחזר ומכנו מכור. It means that the seller of the deed can withdraw and settle. With such a rule, there is no commercial instrument. Now the system can move into, as I said, two opposite ways. It could do what Rav Heiger did. It means to incorporate as קופסה שחורה, a black box, without going inside the suftage, how really it works, without giving it legitimation according to legal system. But that is, we have it from the commercial behavior, minhag הסוחרים, and I accept it. Really, according to my Talmudic law, it doesn't work. It is not legitimate. That is one way. The opposite way is what Ravad in Provence did by trying to change something in Jewish law, changing the formula of the deed so that it would be able to block these two obstacles. Now, when you come to the era of the Gniza, they move in the way of Rav Heiger. It is not reflected at all in Maimonides, in the, I think in the code, in the Tshuvot, yes, but only from the Gniza. And here maybe that I have some connection to Ron Harris. So when you read Mishneh Torah, it totally does not reflect it in Mishneh Torah. And all what, according to Goitan, in the long distance commerce, that it was so important, the suftage, you don't know anything about it. And the other way, what the Rava did, it was in southern France, not here, and it is something very different, and you know, you can't. So what I want to argue is that the connection, the relation between changes in commercial life and in the life of the law could be reflected in two opposite ways. And the Hebrew term that I know is חד ערכי. I sent to my wife to ask her how this translated into English, but she doesn't. חד ערכי. It means that when you have two elements that are connected and that a change in one causes the change.
Oh, a direct relationship.
Eh?
A direct relationship.
No, but it's only to one side.
No, it's on both sides. So, okay. But I think that I explained what I want to say. By the way, there is a very interesting comparison that you can, I'm now working on it, how the rabbinical court in Israel respond to the phenomenon of the bill of exchange, which is a product of English law, but in many cases it comes before the rabbinical court, and how we reacted. Can we incorporate it? It works. Merchants are doing business with it. Simple people are paying with it. So how to look upon it from the point of view of Jewish law. And also here you can see different attitudes. You can see someone who will say, okay, it is a black box for me, it works, it is common in the commerce, and I adapt it according to the basic rule, minhag haSabarim. And there are other response of Dayanim, even in the high rabbinical code, who would try to base it to some extent on Jewish basis, and from this to try to incorporate it to some extent, not always according to the English law, but you know, some parts so and some parts so. And all are living in the same environment, in the same historical period, and they have the challenge of this economic phenomenon, which is also economic legal phenomenon, and the responses are extremely different.
Thank you. Thank you. Final comment, right?
Okay, so I first want to thank you. I think this was an illuminating session, really, from most of you. And Phil, we have a meeting today of the association, and maybe we should think, I think this was a session that should encourage us to think of a different way of constructing the conference. Less presentations, but the way we usually do it here, is a presentation with a comment and a serious discussion. Less presentation, but go more deep. I mean, there's a logic to both sides, but this was an example of a different way of doing it, which I really believe that goes. Now, I want to ask a small question. Maybe it was not my field and I'm not so fully understood everything, but still, I thought that the concept of migration was used between both of you in a completely different way, or in a different way, which I want to understand. It's a geographical migration and a cultural migration. I mean, moves from place to place, as Ron showed us, and culture from one culture, Jewish culture and Islamic culture. And when we talk about geographical migration, I understand what we're talking about. But when we talk about cultural migration, and we talk about merchandises, and in the same geographical place, I mean, how can you do business with two different laws? So what exactly are we talking when we talk about migration of legal ideas within the same geographical area and the same business area? So what basically I want to ask is, my question goes to, can we detach this question from a broader question of relationships between Jews and Muslims in a certain place, and the question of legal pluralism and so forth? How does...
So I think that, right, so I am dealing with the physical migration, but the project as a whole also talks about some cultural, linguistic migrations. That's one chapter in the project. But as for the sort of legal migration from one culture to another, one thing that I argued in this very room at another conference, which Dean Harris organized, was about the regime of the legally pluralistic regime, where I argue that the range of outcomes the Jewish court allowed was not limited by Jewish law, but was also limited by, right, what Jewish law and Islamic law would permit, because the Jewish constituents could go to a Muslim court for a ruling. Therefore, the Jewish dayanim know that if they rule only like Jewish law, that their constituents will go to the other court, which will undercut the authority of the Jewish court. So the Jewish court does not serve to to decide, so much as to provide options and allow the litigants to come up with a solution that they are happy with in that broader range, which means they will not appeal.
we have the same phenomenon in current rabbinical court in matters of...
דיני ירושה. דיני ירושה.
I'm working on it more, sort of. I never thought I would publish more about it, but Ron has convinced me maybe I could write some more about it.
Well, thank you very much. Lunch is on the second floor.